Birthright citizenship. You are about to hear that term a lot in the coming week. And so let's just get something out of the way right off the bat. I really don't care about what anybody says about the issue. It's completely insane for a country to automatically grant citizenship because an illegal hopped the border and had a baby in the country. That is such a bonkers way to handle immigration, citizenship. It's such a degrading way to handle the citizenship of a country. Yet that has been established policy in the United States of America for a very long time. Trump is challenging it, and good for Trump. What's the Supreme Court going to do? What's the history behind all this? I don't freaking know. Let's talk to Josh. Joining me now, my buddy Josh Hammer, host of the Josh Hammer Show, and of course, authored that wonderful book, Israel and Civilization. Hey, Josh, before we get into the idiot Supreme Court, can you give us a little bit of background on this whole 14th Amendment thing?
Sure, of course. So, Jesse, I hate to disappoint you, my good friend, but just for your viewers' awareness, unfortunately, they're not really debating the 14th Amendment issue at the Supreme Court. This is basically going to be an oral argument about the scope of the so-called nationwide injunction. So I care a lot about the birthright citizenship issue, and let's go ahead and talk about it. But we're primarily dealing here with the nationwide injunction, which is a very, very, very important issue in its own right. And I think that SCOTUS is probably well primed to narrow the limits of what these rogue lower court judges can and cannot rule when it comes to the scope of the injunction. But with that, important caveat aside, let's talk about the 14th Amendment there. So the 14th Amendment begins with the citizenship clause. So the very first clause is the citizenship clause, which famously includes this qualifier. It says that all persons born in the United States and subject to the jurisdiction thereof are hereby citizens of the United States. Now, the purpose of this clause is to overturn probably the single worst Supreme Court opinion in the entire history of the Supreme Court, the 1857 case called Dred Scott, which infamously held that Black people are not citizens, could never be citizens there. That was the purpose there. The key thing that is important for purposes of the substantive debate in the 14th Amendment is that qualifier subject to the jurisdiction thereof. Now, for most of the past century, call it a little over a century, close to a century and a half now at this point, actually, most people have read that jurisdiction as just being like, okay, well, if you murder someone, then you can be arrested for that crime. Therefore, you are in the jurisdiction. So by that reading of what it means to be subject to the jurisdiction, Jesse, then any alien, legal or illegal, would be subject to the jurisdiction, because if an illegal alien is here and happens to murder someone, guess what? That alien's going to be arrested there. However, I and many others have long argued that is not the proper reading of subject to the jurisdiction thereof, because the way that the framers used this phrase here, they were talking not just about territorial jurisdiction, they were talking about something that we might refer to as political jurisdiction, as owing your allegiance to a certain sovereign. In fact, if you actually go back and look at what they were trying to do, the 14th Amendment was ratified in 1868. They were actually really just trying to constitutionalize the Civil Rights Act of 1866, which was passed by Congress 2 years prior. And there, the drafters were actually a lot clearer. They said any person born or naturalized in the United States and not subject to a foreign power is therefore a citizen of the United States there. So the better way to read this, Jesse, the best way to read the 14th Amendment here is basically saying that you only automatically get birthright citizenship if you are not subject to a foreign power. So I would take it even further and say that a proper reading of this clause means that the only people that are constitutionally required to get birthright citizenship are people that are born here to U.S. citizens. I would argue that even the children of legal aliens, you're on a green card here, Congress can give you birthright citizenship. In fact, maybe they actually even should, but even that is actually not technically constitutionally required. But the notion that you would automatically get birthright citizenship as a children of an illegal alien is flabbergasting. That would have completely dumbfounded the very wise men who wrote this amendment in 1868.
Okay, so how did we get here then? How did we get? It's obvious to everybody. It's obvious legally. It's obvious to just common sense people. So how do we get to the place where we have millions of people hopping the border, crapping out a kid, and now the kid's a citizen? How did that happen?
Look, Jesse. I mean, first of all, it's not even a legal disaster, as you accurately point out. It's an absolute policy and moral disaster. I mean, we literally have an
Yeah.
entire birth tourism industry here. I know that because we just had our first child last December, and when I went with
Mhm.
my wife to the OBGYN here in South Florida, where we live, you literally see foreign people, especially here in Florida, a lot of Russian-speaking folks from Eastern Europe that are literally just here for purposes of getting a visa on their eighth, ninth month of pregnancy to pop out a child. So it's completely insane. I mean, it is an absolutely insane policy, to say nothing of the way that it incentivizes the coyotes and the cartels down in northern Mexico to transport vulnerable young women in the seventh, eighth month of their pregnancy to get across the border. It's totally nuts. The basic way that we got here is that, so for the first two and a half, 3 decades after the 14th Amendment was ratified, so we're talking here of the late 19th century, the Supreme Court actually got it right. In fact, the very first time that the citizenship clause of the 14th Amendment is actually explained is in an 1871 case called the Slaughterhouse Cases. And there, Justice Samuel Miller reads it in the correct way, this notion of complete jurisdiction, political allegiance, and so forth. It starts to go off the rails a little bit in an 1898 case out of San Francisco called Wong Kim Ark. So the fact pattern in Wong Kim Ark, though, Jesse, is actually very important. So in Wong Kim Ark, the fact pattern is that you have Chinese aliens here. So people who are citizens of China, they are subject to what was then the king of China, the emperor of China. And but they're here legally. They're not illegal aliens. So there the relevant legal question was, does this child get 14th Amendment birthright citizenship? And the answer should have been no, for the reasons that I just gave there, is that even a legal alien does not have complete jurisdiction, political allegiance. But even in this opinion, and even in this opinion from Justice Horace Gray, which the liberals love to quote here, he goes over and over and over again and makes a repeated point of emphasizing that the Chinese alien here was actually a domicile, had a legal permanent residence in San Francisco. Put another way, even the case that the liberals love to cite on this point, Wong Kim Ark, only stands for the proposition that the children of legal aliens have birthright citizenship. It says nothing about the children of illegal aliens. Where it goes off the rails even further is 84 years after that, in a case out of your state of Texas called Plyler versus Doe in 1982, you had one of the most liberal justices of the entire 20th century, Justice William Brennan, who literally drops in a footnote. And anyone who reads cases knows that footnotes are not legally binding. This is what lawyers call dicta. He literally drops in a footnote, it's very liberal justice, and says, "Oh, by the way, Wong Kim Ark established that everyone gets birthright citizenship." Well, no, you freaking moron. It didn't establish that, because they said time and time again it has to do with those who are domiciled here, legal aliens, not illegal aliens. But for whatever reason, Jesse, ever since Wong Kim Ark, especially ever since Plyler versus Doe, people just automatically assume that the birthright citizenship clause guarantees that anyone born here gets citizenship. It is a misreading. It is historically illiterate. It's legally illiterate, and it's had absolutely disastrous policy ramifications as well.
All right, Josh. So you mentioned they are dealing with the nationwide injunctions, and dare I say you sounded a little bit hopeful. What's going to happen?
Yeah, so I'm actually much more hopeful on the injunction piece of the puzzle than the birthright citizenship. So, as convinced as I am that what I'm arguing is correct on the birthright citizenship point, Jesse, I don't think, unfortunately, that there are 5 votes for that proposition. I genuinely don't. I think you're looking at literally probably 2, Clarence Thomas and Sam Alito at the most. It actually wouldn't shock me if even one of them disagreed there, because this is one of those things that's just become so well ingrained that even very, very smart, very conservative, very originalist justices have become convinced that this is actually a very close call. So I'm actually, unfortunately, not optimistic on the actual substantive 14th Amendment question, but I am optimistic on the nationwide injunction issue, because there you're being asked to basically define what is and what is not the judicial power in which Article 3 of the Constitution speaks. And here, Jesse, there's only a very, very recent history of these so-called nationwide injunctions. The very first so-called nationwide injunction literally didn't happen until the late 1960s. It was like the Lyndon Johnson or the Richard Nixon presidency, and they didn't proliferate until the first Trump presidency. Donald Trump, when he was president the first time, from 2017 to 2021, faced more nationwide injunctions than the first 44 presidents combined. So this is a much more recent phenomenon. It is risibly unconstitutional. The judicial power of the United States clearly only only comprises the ability to issue a judgment, a ruling that binds the named parties to a lawsuit. And more generally speaking, when it comes to these very structural constitutional questions, Article 1, Article 2, Article 3, separation of powers, checks and balances, these are typically the kind of questions, Jesse, where I actually have faith in even the more, well, I have some faith, let's say, and even the more moderate justices here, Kavanaugh, Barrett, John Roberts there. All else considered, they're better on these questions than on these kind of, let's say kind of race adjacent questions such as birthright citizenship.
Ugh. Okay, well, that's something, I guess. Josh, as always, thank you, brother. I appreciate you. I would thank you for coming to my YouTube channel, but I know how brilliant it is, and I know you love it here. So subscribe and watch. We're going to start really ramping things up and putting some funny stuff, some interesting stuff out there, some collaborations. Either way, my YouTube channel is officially the place to be. So stick around.